We all know by now that R. Kelly was a victim of prejudice, and this we have mentioned time and again in our previous video releases. It's however important to note that there are various ways a defendant presented in the courts of law can be prejudiced. One of the ways a defendant can be prejudiced in court is by allowing the government to present numerous uncharged bad acts that are not in any way related to the charges listed on the indictment. What this portrays is an intention to convince everyone present in the court and the general public following the case that the defendant is a very bad person using bad acts that are not necessarily illegal, or that are not necessarily chargeable by law, or those to which the government lacks sufficient evidence to add to the indictment, such that when they get to the actual charges on the indictment, they are already biased to think the defendant has to be guilty after all. While the court system may allow a few to a maximum of 7, a prejudicial judge may end up allowing excesses of these, and this will tantamount to prejudice. During the New York trial, the district federal judge Ann Donnelly allowed the government to present way over 40 uncharged bad acts, which is tons in excess of what the acceptable threshold should be. They invited into the courtroom numerous witnesses, all presenting uncharged bad acts to convince the jury that R. Kelly was a monster he isn't. According to Bonjean's appeal submission, over the defendant's objections, the district court allowed the government to admit testimony about defendant's uncharged alleged sexual misbehavior with at least 8 other individuals, including testimony from Angela, Addie, Kate, Alexis, Louis, Alex, and Anna. The district court also permitted several witness testimonies through medical documents about defendant's history contracting sexually transmitted diseases, including herpes and his alleged transmission of herpes to women other than any of the complainants. The same district court allowed the introduction of said evidence related to defendant's alleged mistreatment of employees, including docking their payments for violating his policies and rules. Matters that were completely unrelated to the indictment charges. They also allowed into the courtroom audio recordings of alleged verbal and physical assaults of his girlfriends that were completely unrelated to the charged offenses. Several video clips showing actions unrelated to the indictment were shown for the entire jury to watch, and these were all acts of prejudice. Despite filing a motion for a new trial based on the court's admission of excessive and highly prejudicial bad act evidence, the district court adamantly denied the motion. Like Bonjean quoted somewhere in this same appeal submission when she said, "It is indeed difficult to conceive of a more effective obstruction to the judicial process than a juror who has prejudged the case." This is because due process means a jury capable and willing to decide the case solely on the evidence before it, and a trial court ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. We are glad to note that the matter of prejudice is an element of law the appeal court takes rather seriously. And here is an example of an appeal court session addressing prejudicial tendencies that involve multiple uncharged bad acts with a no-nonsense approach. Take a look.
Wasn't that accomplished with the 3 women who were complainants? I mean, that for me is the problem. You already have 3 women who give you 3 different types of stories of the horrors they experienced with him. I think you've covered that. So to pile on with 3 uncharged complainants, 3 uncharged victims, is leaning really close to that propensity line.
It was relevant to defendant's intent. As Your Honor pointed out, intent was hotly contested below.
I don't understand how that wasn't established through Mann.
Because
who had a 5-year relationship with him after the assault.
Because Mann's allegations were not so unambiguous that there would have been no doubt in a juror's mind that defendant intended the forcible element of the first-degree rape. Again, when Justice Burke...
You're saying that you wanted to prove what he did with Mann by introducing the testimony of those other 3 women.
No, certainly not. Mann's allegations would have established, if believed, would have established the elements of the offense.
Where the women were of the uncharged crimes were not the victims for which were being prosecuted, though. Where was the balancing that's supposed to go on in Molyneux? This was incredibly prejudicial testimony, no?
Well, no, respectfully, Your Honor, it wasn't prejudicial for 2 reasons. One, the court gave extensive limiting instructions. 3 times the court explained to the jury...
The fact that there's instructions doesn't mean it's not prejudicial.
But here we know it wasn't...
I'm being charged with 3 rapes. And here come 3 other women who claim I did the same thing to them, but I'm not being charged with that. That's prejudicial.
Well, it's not prejudicial.
So the question is, does that prejudice, is that outweigh by some probative value that supersedes that.
Respectfully, Your Honor, it wasn't prejudicial here, and we know that.
Opposing counsel referred to the Molyneux rulings in this case as unprecedented. What cases do you rely on under New York law that actually constitute precedent for the court's rulings in this case on the Molyneux issues?
Well, parsing the Molyneux evidence, no one would quibble with the admissibility of the uncharged offenses as to man. Ample case law, which we...
I'm talking about the other three women.
Right. As to Young, Dunning, and Wolf, again, I think Vargas is a perfect illustration of precisely why we were permitted to put forth the evidence here. It's well understood that Molyneux evidence can shed light on a defendant's state of mind and intent.
So you're really arguing that this was not overkill? I mean, there were certain items in the Sandoval that I thought, okay, that's fair game. If you, after being fired, ask an employee at the company to take computers and delete stuff, that's fair game. But some of this other stuff, let's inflame the jury's heart by telling them that he beat up his brother during a meeting. I don't see how there is a balance there on that.
Well, threatening behavior, again, goes directly to demonstrating his ability to put his own self-interest at the expense of others, and that goes to the heart of honesty and integrity. The fact that there were many of these acts only indicated how defendant chose to live his life.
Yes, and counsel, you know what? There are trials every day where we have defendants who have a rap sheet a mile long. A mile long. They'll have 20 felony convictions on their rap sheet. And I see no judge say, go ahead, go to town on all of them, because they don't let you go into the facts. They usually just let one or two in. I mean, there is a balance.
But looking at what was let in relation to its impact on whether the jury could otherwise decide the case, not based on the fact that this is just a horrible person. That's really the balance, not what was let out.
That's correct, and perhaps if this involved a case that had 100 or 150 allegations, it would present a different scenario.
38 non-convicted, and they're not convictions, not one of them, acts. That's balanced?
Well, as you point out, the fact that they're not convictions, that they're just bad acts, if anything, makes them less prejudicial. But the fact that there were so many is only indicative of how defendant lived his life. The court was not required to unduly sanitize
which
them.
proves the point. You're saying this is just him. He's a bad guy. There's a lot of acts because he's just bad. So, to say it's indicative of how he lived his life, he doesn't get convicted because he's a bad guy. He gets convicted for these particular crimes.
Thank you for watching LFN News, a production of LFN Media, giving you another view of issues at hand. To get notified whenever we post a new video, subscribe to this channel now. And remember to give us your comment on the subject matter below.